Hello, my name is Todd Pierce-Ryan. I'm a staff attorney with the Systemic Advocacy Unit with Lakeshore Legal Aid. Lakeshore is a nonprofit law firm that provides free legal advice and representation to low-income people, as well as seniors and survivors of domestic violence and sexual assault. This screencast will walk you through what you need to know about renting in Michigan. It's illegal for a landlord to treat you differently than other applicants because of your age, color, race, sex, religion, disability, place of birth, or family or marital status. If you believe that your rental application is being treated differently for any of these reasons, contact the Fair Housing Center in your area. Here are some examples of discriminatory practices. Other applicants can visit the rental, but not you. You're told the property is already rented when it's not. Others are being offered the rental for less money. You have a disability but are being refused reasonable accommodations. The terms on your lease agreement are worse than other renters. Before you rent, there's a wide variety of questions that you may want answered before you commit. So you want to know that the person you're dealing with actually has a right to rent the property, that they're the property owner, or they're acting on behalf of the property owner. You want to know what you're committing to in terms of money. You want to know what the rental rate is, as well as any fees. There's a wide variety of fees that could include pet fees, cleaning fees, or potentially late fees. And there's a security deposit in many cases. You want to know upfront what all you're committing to. You also want to know what happens if something goes wrong with the property, if you need repairs. Who's responsible for the repairs, and how do you go about getting them? The paperwork is really important. Make sure to sign the lease and know what you're committing to. With the lease, there should be a move-in checklist, and if there's not, you can ask for one, or you can make one for yourself to document the condition of the property. When you do that, and before you move your stuff into the rental, it's a good idea to take pictures of each room and note any issues on that move-in checklist if you have one. Be sure to take pictures or videos of anything that's damaged, like chipped paint, cracked windows, or stained flooring. This is a way to protect yourself if there's a dispute later. Sign and date the checklist, make a copy of it, have your landlord sign it, and keep a copy for yourself. You have the right to live in a home that's in good condition. That means the landlord must make all repairs necessary to keep your house, yard, and any common areas in good enough shape for normal use. Your landlord is required to make repairs in a reasonable amount of time after being notified of a problem. So let your landlord know about problems in writing as soon as possible. Check out michiganlegalhelp.org for more on do-it-yourself repair letters to landlords. As a renter, you have the right to quietly enjoy your home. Your landlord cannot enter your home without your permission, except in emergencies, or do anything that keeps you from your home. If your landlord needs to come into your home to make repairs, they should let you know in a reasonable time before entering. If you've requested repairs, but don't hear back from your landlord after some time, send a letter to your landlord detailing the needed repairs. Send the letter by certified mail, return receipt requested. Keep a copy of the letter, the certified mail receipt, and give the landlord a chance to make repairs. If still no repairs are made, contact legal aid. A landlord may ask the court to evict you if you deduct the cost of repairs from your rent or put rent into an escrow account. If that happens, show the judge pictures of the issues and the repairs you paid for, a copy of the letter you sent the landlord requesting those repairs, and the certified mail receipt. The court will use this information to decide if the landlord can evict you. If a security deposit was required when you signed a lease, when you move out, you can get your deposit back if you give the landlord written notice of your new address within 4 days of moving. The landlord may keep some or all of your deposit to pay for damage to the rental beyond normal wear and tear if he gives you written notice of damage within 30 days after you move. You have 7 days after receiving the notice to dispute the damages. The landlord must ask the court then to keep your security deposit within 45 days of the move or give you back your deposit. Thank you for watching. Here are some legal aid resources that can help. Take care.